All right, then I think we're good to go. I'm going to start off by saying thank you to everyone for coming out. Thank you, especially to Fitzpatrick, Lentz, and Bubba for putting this together. Andrea, Jennifer, you guys did a great job putting this together. It's easy to come up with an idea. It's a lot more difficult to execute, and you got everyone here. So thank you guys so much. And thank you to everyone for being here. I know it's very cold out there, and events are being canceled left and right. So thank you for braving it. If you're here because your boss harassed you to be here, you're in good company. And thanks to Notch. I think this space is perfect, and it'll lead to a good conversation. So, before we jump in, I wanted to introduce everybody on the panel so you know who is here and who you should be listening to. And we'll start with Jackie Plunkett. Jackie has over 25 years of experience in HR, and kind of you name it, I think she's done it. Small business, large business, varied roles from in-house HR to a consultant throughout the U.S. Currently, she's a solution consultant for iSolved. She collaborates with U.S. companies to deliver tailored human capital management solutions, which is a fancy term,
yes.
Through the intelligently connected People Cloud platform. She holds professional designations of Professional Human Resources from HRCI and SHRM CP from the Society of Human Resources Management. That's a lot to say. You're very qualified to be here.
I cut it down for you.
So thank you very much for joining us. Up next, we have Dave Steckel. Dave is an attorney at FLB and member of the Employment Law and Labor Relations Group. He serves public and private employers, counties, townships, and municipalities in a wide array of matters. He has deep knowledge of employment law, public sector, labor law, and he has counseled clients and litigated cases involving the full range of employment issues. And he has conducted collective bargaining negotiations, handled grievances and interest arbitrations on behalf of numerous counties, boroughs, and townships. He has also conducted hearings and mediations before the Equal Employment Opportunity Commission. We'll hear more about that later. The Pennsylvania Human Relations Commission, the Pennsylvania Labor Relations Board, and the State Civil Service Commission. Dave, thank you very much for being here.
Thanks, Jimmy.
Absolutely.
Pleasure to be here.
And then last but not least, Jake Sitman. Jake is a shareholder at Lehigh Valley law firm, Fitzpatrick, Lentz, and Bubba, and chair of the firm's Employment Law and Labor Relations Group. He counsels and trains business owners, executives, HR managers in crisis situations, ways to reduce the risk of legal claims, and how to make smart, strategic, and cost-effective personnel-related decisions. He drafts employment arrangements, personnel policies, and represents employers in federal and state courts, defending them against claims of discrimination, harassment, whistleblower, breach of contract, wrongful discharge, workplace safety claims, and more. That's awesome. He has also been successful in wage and hour, non-compete, and trade secret litigation and appeals. That's what we're talking about today. So thank you for being here as well.
Happy to be here.
Awesome. And then last but not least, I'm Jimi Honochick, president of YMI Insurance. Got my MBA from Columbia and went into equity research at a large wealth firm where I studied businesses and thought about them from an investment perspective. Before I entered the insurance business, where I now look at businesses and help them mitigate sort of their downside, risk mitigation, and protection practices like that. So this is the team. We are here to talk about HR risks. This is the first ever Executive Edge. I hope it will not be the last. I think this will be a quarterly event, and really looking forward to diving in. I hope it'll be, give and take. If you guys have questions as we're talking, please feel free. You have some incredible minds on the topics here. So with that, let's get started.
All right.
So the first question I have, as I look out here, I see lots of different industries being represented. So what do you see? There's white collar, there is, the trades. What do you guys see as sort of common occurrences or claims or things that both of those industries types face?
You want to start, Jake?
Yeah, Dave and I were talking, so it's hard to come up. We initially said, let's give a top 5, and it's kind of difficult just because there are so many to list the absolute top 5, but there are common ones we see pretty much every week, if sometimes every day. Mm-hmm. So the most common types of issues where you're counseling or defending claims, they tend to be discrimination. And those discrimination claims run the gamut. They can be any more religion, race, age, sex, disability is hot now. Mm-hmm. So, but to lump them together, discrimination is one. Retaliation is another, meaning somebody at work complained about something or objected to something that was arguably unlawful, and then they're later disciplined and they suffer some type of adverse action. They're effectively a whistleblower. So we're seeing more of those types of claims.
In addition to that, I mean, disability discrimination, and what goes along with that is the obligation of the employer to engage in the interactive process to try to find a reasonable accommodation when someone has a disability. So that's a huge one. We deal with that all the time. Also FMLA, leaves of absence are huge. They're almost every workplace deals with them. And one of the biggest complaints we get from employers is the potential abuse of leaves of absence. And they are easy to abuse, and you have to keep tabs on those. As Jimmy mentioned, I also do some union work, and one of the biggest union issues I deal with is violations or perceived violations of the collective bargaining agreement, and the employer's lack of consistent enforcement of policies, which leads to grievances, grievance arbitrations, and whatnot. I feel like we're leaving a couple out yet.
Yeah, so wage and hour claims. So people out arguing they worked more hours or they weren't paid overtime correctly, the bonus wasn't included in the overtime rate, or whatever the case may be, or they're not really exempt from overtime, but they're classified as exempt.
Perceived as a manager, and maybe paid as non-exempt.
Yeah. So, we're seeing more and more of that. Look, the new laws are being passed every day, particularly under the now former administration. Things are anticipated to be very different in the next administration, but we have the Pregnant Workers Fairness Act, for example, which is brand new just last year. So now you need to accommodate in a formal way all pregnant workers, and that wasn't legally the case before. We all knew we had to engage in the interactive process with disabled people, disabled in quotes, everybody's disabled under the law. But now we need to do that with pregnant people, and there are specific requirements. And that's in addition to other things like giving time breaks for lactation, et cetera. So the world's gotten a little bit more complicated, and I think as it's gotten more complicated, we're getting more and more of those types of issues when our clients are picking up the phone and calling us, Jake, here's the new one. What do you think, kind of thing?
Also seeing some independent contractor versus employee issues. The DOL, Department of Labor, issued revised guidelines last year specifying how someone can be properly classified as independent contractor or employee. It's much more difficult to classify somebody anymore as a 1099 independent contractor. So that's a big issue. OSHA, I deal with that fairly often, particularly in more industrial manufacturing settings, obviously. But that one comes up fairly regularly. And also food service. I see some of my restaurant clients, OSHA. You have a disgruntled employee who, the last one I had, they completely made a bunch of things up, and then they put that out online, and you have to nip that in the bud quickly and get to OSHA and have them investigate and hopefully clear your client's name, because these days it doesn't take long to ruin the reputation. All it takes is one disgruntled employee and who has easy access to social media. These days, who doesn't, right?
All right, so you guys gave me a lot of directions I want to take this. I'm going to give Jackie a chance to start here. Hearing the common concerns and incidents that businesses face, what are ways that management, ownership can mitigate those or set themselves up to be successful and reduce the amount of claims that they see?
So we're talking about the setup before there's an incident. So a lot of the claims come out of treatment. People feel they're being treated unfairly. So if you communicate and do your best to speak to people, hear their issues, treat them with respect. And if an investigation is needed, that's great, but you have to be fair and consistent with that. And a lot of times I would always recommend call legal experts. If you feel like you're being set up, it's time to make that phone call, because one misstep can set up the whole thing for error. Essentially, and I'm sure you guys would agree with that. There's so many mistakes that you can make in answering claims, but by avoiding people, things fester, issues get worse, people can't get answers, and it makes them seek legal counsel from, as a plaintiff, to get some answers for themselves. So if you're addressing those concerns before they become bigger, whatever they are, it puts you in a better standpoint.
And Dave, you hit on restaurants, but are there industries in particular where you see more incidents arise than other industries?
By incidents, do you mean just general employment claims?
Yeah.
It really runs the gamut. Every place deals with them. You know, the leaves of absence that we talked about earlier, the disability discrimination, reasonable accommodation, FMLA, those hit everywhere. And of course, the other discrimination kind of claims that we mentioned, the age, race, ethnicity, they really don't discriminate. They hit every type of industry. So now I don't see an overwhelming amount of employment claims in one industry versus the other. I think that it just, there's so many of them. There's so many different types of employment claims that they hit every industry out there. Yeah.
I would say some of the industries that have higher turnover, just by nature of the very business itself and the number of hires that they have, the number of employees, they tend to breed more claims. So just as a sort of matter of the function of the numbers. And then, so you're going to have more claims when you have more high turnover type employees. But conversely, if you have a sort of a more professional setting and maybe even fewer employees, but they're highly compensated, you may not have as many claims, but the claims that you do get are going to be more dangerous. You're at risk for greater liability when they do have a claim. So if you're the senior anymore, I'll just tell you, it just seems like we get, sort of to give you an idea, we get a daily blurb of all the new labor and employment cases and legislation that's come out, believe it or not, every 24 hours or so. So we peruse them, and what we've seen is, for example, a lot of HR managers and employers and executives filing claims. Those claims, though historically infrequent, seem more frequent. And I'll suggest to you, when there's a risk of liability, it's higher for them for a variety of reasons, one of which is they make more money. And so when they win a lawsuit, they win more money. It's that basic at a certain level.
Yeah.
Talking about you, Jack.
I know. We know where the bodies are buried.
That's part of it, right?
Mm-hmm. You hit on something, Jake, the change of administration and also keeping up to date. You guys regularly keep up to date. Any expectations on what might change given the change of administration?
Yeah, I mean, a couple things are easy, right? Particularly with employment. So you guys might remember this past year, there was a big to-do when the FTC, the Federal Trade Commission, issued a new regulation effectively banning almost all non-compete agreements. So we had a lot of clients at that point calling us and writing to say, what's going on? Well, a lot has happened since then. The courts have effectively put that on hold. I don't anticipate the new administration going forward with anything like that. I anticipate it being, but you don't know. We'll have to wait and see. But we've already seen, for example, that I just saw this today. There's a new interim head of the EEOC, the Equal Employment Opportunity Commission, just appointed, I think today or yesterday, and apparently has a problem with corporate DEI programs and has made that a focus of what her past life has been and will make it a focus of enforcement going forward. That's not something we've had to contend with so far. So just a couple of examples. So you're going to see, unfortunately, dramatic shifts, I think. You would hope the law as it evolves would do so at sort of sensible pace. I don't think that's what we're likely to see. I think we've seen the pendulum swing one way pretty dramatically, and I think we're going to see the pendulum swing in the opposite direction equally dramatically.
Leads me to a question, Jackie, maybe for you, but maybe for everyone. What role does training have in terms of, reducing these or what role does it have in HR risks? I think of DEI, but now compliance, harassment, these sorts of things. How should businesses be implementing those?
So it's best to have policies, and if you have policies, write them down, and then make people aware of those policies and communicate them regularly. Because the more that people are aware of what the rules are and what the parameters are, you can have less problems overall. But think of how many times you want to answer questions over and over again. If you put those materials in front of people and tell them how to handle complaints and grievances, you're also going to stop a lot of the gossiping and the problems that start when people are upset and they just go chatter to other people. If they know how to direct their issues and where to go for help, that cuts down on a lot of it. But it's about tackling those issues. When you see the storm starting, you really want to jump in there and find out what it's all about. Pool your own resources, see what you can tackle. Having those policies and everything is the great first step. So training your managers when to realize things are getting out of control. Somebody said that they had an FMLA issue. Okay, you gave them the FMLA. They came back. Then they had an absence that you don't believe was real and gave you what you think is a fake doctor's note. You're not a doctor. So you really have to be careful how you proceed with those things, because even if it's not tied to that FMLA, you can be accused of retaliation for someone taking a legitimate FMLA leave before that. So you have to be careful. But if your managers can pick out when these things are brewing, when the storms are starting, when the chatter is happening, it helps. You never want to be that employer that gets dragged into the news, that gets called out, the defamation, all of the issues that can happen. So you really need to make sure that your employees are aware how to handle claims, when they have problems themselves, and how your managers can spot them and how to deal with them confidentially and get things to the right people to be resolved.
How does the HR role or person balance, being an employee advocate and being them for there, but also protecting the business? How do they deal with that tension?
It's the monkey in the middle. I mean, it's HR.
Yeah.
So your HR people are employees too. So, they work in the company. They want to protect the company. They want to hopefully do what's best for everybody involved. But it's a tricky step. And sometimes it is hard to balance that. You have to be very careful about treating everybody confidentially and respectfully. The more confidential you treat things, so if somebody has a problem and I blab about it, they're never going to come to me with their problem. All of these things are perception. You have to be very careful. It's a very tricky place. But, in investigations, when things are going on, don't chat amongst other managers unless they're involved in it, if there's a reason to involve them. So it really just comes down to, kind of a business acumen, really, knowing who to involve and when, but keeping things close to the vest. You can't always give reasons. Employees ask you, and I just told you to communicate, but you can't tell them the reasons behind things. If there are protective reasons, you're protecting somebody else or an issue that's happening. You want to make sure things are handled professionally, quickly, and completely. So, honestly, that's always when I've told clients, you probably need to speak to an attorney just to see, because a small problem is going to cost a lot less than when you've tried to solve something that might have been out of your realm. And now, now you really need both of them.
Jake, I saw you nodding a lot there. Is that when it gets to you, when it's finally bubbled to the surface like that?
Often, look, there's a spectrum. There's sort of business owners and managers and HR professionals who think they can handle what they can, and then they call us too late. But there's a whole host, fortunately, who know, they have a good sense of when things have gotten to a point where, hey, look, I'm not confident. Let me see if I can get some advice to give me more confidence as to how to handle it. So it really is a spectrum. You have to go back to your own workplaces and decide for yourselves, like, do I have the right? We were talking about this also, which is if you have good, reliable people in-house to digest whatever's going on and make informed decisions as to when to pull in an outside resource like us, like a consultant, like an attorney, that's fantastic. Some of us don't have that for whatever reason, either because we're in transition. We just know that the people we have in place aren't ideal. We can't really rely on them for that level of discretion. So, and unfortunately, though, there's a segment who we handled it the way we handled it, and now we're in trouble. Well, unfortunately, litigation is time-consuming and expensive, and there's just virtually no way to avoid it. Once you're at that point, you're in for a nickel, you're in for a dime, you're in for a dollar. It's not an enviable place. But conversely, you can do everything under the sun correctly in-house, have the best people doing the right things. You've in fact done the right things, and inevitably you find yourself having to defend an employee claim. So that's not a reason not to do the right things. It's just, don't beat yourself up for having been sued effectively, because sometimes, frankly, it's not your fault. Employees who perceive to have been treated unfairly, and they're pretty convinced of that, you can't dissuade them, and they'll file their claim anyway.
And I guess that comes to me now. So claims. Before we jump there, you had an analogy that I thought was really good when we were talking before this. Could you just shed a little light on what that is in terms of protecting a business?
So this is not my invention, but I thought it was sort of a great, simple way to think about how to mitigate personnel-related risk in the workplace. And it was described to be the three-legged stool, right? And one is have good policies, Jackie mentioned this, and people in place who are well trained. If you can do that, you've automatically, right off the bat, cut your risk of nonsense and expense and distraction, etc., remarkably. Okay, so that's one leg of the stool, is in-house, get your act in order, right? Whether it's the right people, the right documents, policies, training. But then the second one is also to have outside professionals available for when, despite being okay inside, you need additional resources like we talked about. Oh, this one's more complicated. Oh, I've never seen this version of circumstances again. You have good accountants, lawyers, and insurance brokers because they can help you. Sometimes it doesn't even cost you anything, right? We're generally well connected. When you have people who you can trust and rely on them, and they can save you a lot of time and money. And then the third piece really is the insurance. So you'll have the right inside people, the right professionals to call on when necessary. Inevitably, you might have that claim, right? That despite your best efforts, you're defending a claim, then you still need insurance, and that's when it comes up. And the insurance for employment claims is often called EPLI or EPL, which is Employment Practices Liability Insurance. And we defend our clients sometimes because they don't have insurance. We defend them directly, or the insurance company will retain us effectively to defend the insured under those policies. And those policies come in a variety of shapes and sizes, but the basic premise is for most claims you might encounter in the workplace, the policy coverage will pay for things like your lawyers, and if you're found liable, the liability. So it can be, those are the three legs. It's in-house people, out-house people like us, and then, perhaps insurance. And by that way, you've really mitigated your risk to the extent you can.
Yeah. While we're on it, I wanted to talk about something we've mentioned, which is right to counsel. And so your EPL policy, it is great in the sense that you had all the defenses and someone still files a claim. You've been working with Dave, you've been working with Jake, you have all your procedures that Jackie told you to put in place, and someone still files this claim. And you go to Jake, you go to Dave, and you say, hey, I filed the claim. Come on, everybody, all the stories, come help us out. And the insurance company says, no. We have the right to counsel. We choose the counsel for you. And that can be a real fracture. That can really, affect the relationship with your insurance broker, but I'm sure it can impact you guys because you have to sit on the outside. And so that is something to have a conversation with your insurance broker about is, does this policy give me the right to choose counsel? Because you ultimately, you have the good relationships with your employment counsel. Not all policies are going to give you that. And I will say that the policies that generally don't are the ones that are sort of built into a commercial package. So your commercial general liability, your commercial property, it'll be another line item and it'll be EPL. And it's great to get people, it's a gateway drug for EPL coverage. It's a great way to get them started if they're hesitant, but it's not a great way to really specialize and get them the best coverage. And so we go to markets for standalone EPL coverage. We'll go to Philadelphia, we'll go to USLI, people who specialize in that. And it gives you more robust coverage. It gives you the ability to choose your counsel. And so that's something I just wanted to bring up because, experiences from you guys, I'm sure, having to watch your clients go in a different direction, it's got to be challenging.
Yeah, and most of my clients who have had to go with EPL counsel, they're not thrilled initially because, like you said, Jimmy, we're the ones who know the clients the best. We've worked with them over the years. We know the players. We know the issues. And then it has to go to insurance defense counsel who has that steep learning curve of learning all those things while having to defend, a complaint, get into discovery. And on top of that, and my clients who have been upset about having to go with insurance defense counsel, what they'll often do is when they've come to the realization that, okay, they have to go that way, something will come up and they'll send me an email or they'll call me and say, hey, this is what's going on. What do you think about that?
Yeah.
And it puts you in an uncomfortable situation because you have a lawyer for the insurance company who's acting on behalf of that client. But since it's been my client for the last how many years, they want to talk to me to make sure that I agree with it. Mm-hmm. So it just puts you in a difficult situation. Another thing I've found is a lot of times insurance defense counsel, and I don't want to throw all insurance defense counsel under the bus, but they have an absolute boatload of claims that they have to handle. And I think they try to get as many of them off their desk as quickly as possible. And sometimes that results in just trying to settle a case as cheaply as possible, regardless of the fact that the case had very little merit to it. And that drives a client insane because they, like we've talked about, a lot of clients will do their best to follow all the steps and do everything right. And regardless, they still get sued. And they want their lawyer to back them and to defend them aggressively. But then they get sent to insurance defense counsel, and they find a lot of times that it doesn't happen. They're just a number, and we can settle this for $30,000 right now. Let's do it, regardless of the fact that there was no real legitimate claim there. Mm-hmm. So it's a constant frustration of clients, and I'd like to see more clients purchase, the ones who are going to purchase EPL, do so with the option that they can still retain the counsel that they've used over the years.
Yep. No, I agree. Another thing I was going to bring attention to on the EPL front is it is claims made basis versus occurrence basis. And I don't know if you guys run into this at all, but most of us are used to occurrence basis for our policies, whether it is your commercial liability, whether it is your auto, your home. And what that means is if there is an occurrence during the policy period, you have coverage. Even if someone comes back 2 years later and says, I slipped and fell on your property, 2 years ago, I'm now suing you, your policy will respond to that. EPL is different. It's claims made, and it means that the claim and the reference to the insurance company need to happen during the policy period. And so what I mean is if you get an email in December and your policy goes from 1/1 to 1/1, and Steve says, hey, I've been the subject of harassment. I'm going to seek monetary retribution for this. And you say, look, it's the holidays. We got a lot year end. Let's forget about it. We'll talk about it in January and we'll address it then. January comes, you forget about it. February comes and you get suit papers. Well, you were supposed to report that on the previous policy period. Your carrier can reject that claim because you didn't report it when you heard about it. And that's something that people don't understand. And so we always advise, if there's an issue that you're having conversations with legal counsel about or HR, and you think that there could be a claim, you should report that to the carrier right away. It's just something to be aware of. It's different than other policies.
Yeah, what we've found too, sometimes our employer clients are reluctant to report a claim or a suspected claim. Because, we all have auto insurance, and we're like, well, what if I report the claims, right? It doesn't really work that way. EPLI isn't really, I don't think it's that rate sensitive to those types of claims. Particularly, sometimes you'll report them, they're not in fact claims. So I would just encourage you, just based on some of the experience with clients, if you think you have a bona fide claim, speak to your lawyer or speak to your broker, and just report it. There's really little, if any, downside to report it. You're better getting the toehold in and that a claim was filed than later realizing, oh, I missed the deadline, or it was under an old policy. It's not in effect anymore. And then another war story is we actually have one client who's been hit with a claim, and they went from a claims made policy to an occurrence policy, and they didn't speak to their broker. It wasn't the same broker. And bottom line is there was a gap in insurance. They thought they were covered in consecutive periods, but because of the type of EPL policy that they had changed, they didn't appreciate that, nor would most of us, right? Insurance is complicated, right? So, but if you have a competent broker, they can guide you through those issues and help you avoid a gap in the insurance, right? You effectively paid for 2 policies year over year, and now you have a claim that's not covered. That's not a good position to be in.
100%. And there's ways to mitigate that without boring everyone. So definitely have that conversation with your broker. What are best practices, I think this will go to you, Jackie, for documenting incidents? So we don't want them to turn into suits. Sometimes they do. But as things are happening, we want to make sure our ducks are in a row. What are best practices in terms of documenting?
So, I think, Jake, you said this. If you didn't document it, or if you didn't write it down, it didn't happen. So, it's completely true. If you didn't document it, it never happened. And your memory changes. So I usually recommend it's not enough to put it in a personnel file, because you put it in the file and it goes away. So I know many people in this room use an HCM platform, an HRIS that has the ability to track notes on performance. You want to put that there too, so that anytime there's a conversation or something, because what if you are no longer managing that group, but a different group? When you take over that group, were you given a turnover about the attendance issues with different employees and things like that? You need to track that documentation to see patterns. You need to make that available to other managers while keeping it still confidential. So, I mean, not every gross and gory detail sometimes, but just documenting an incident itself or having a way that other new managers can follow those incidences too. A larger company has bigger problems with documentation than a smaller one. If you're a 25-person company, it's easy to know everybody and their issues, and fortunately, probably everyone knows everyone's issues. But in a larger company, or maybe groups change over and things like that, it's more important to keep that detail somewhere. So, I mean, the documentation is huge. It's the first step to anything. It's the first step to your defense. It's the first step to your protection. It's everything.
When you call Dave or me about these things, that's the first thing we do. All right, tell me about the claim. All right, so send a copy to me. And then we start asking you for documents, because we know if we're going to defend you and be successful, that's the most valuable thing we can have.
How many times do you get the phone call where they want to fire somebody that day or the next week? And we're like, why? Well, because they're terrible. Their work performance is awful, or their attitude's terrible. Like, okay, what do they have in their file? What kind of disciplinary actions? What do their performance evaluations look like? Either they don't have them, or they're all good. There's no discipline in their file, or their performance evaluations are all, outstanding
But
or
even
above
that,
average.
let's say you addressed it. So you talked to somebody about a problem and you put a little memo in the file. Well, if you sat down and talked to them, have everybody sign it.
Right.
Because you already had the conversation. It's already uncomfortable. Document it. Get the signature on the policy. Get the signature on the conversation. Make sure you have that they were made aware of their responsibilities. If you're telling them, write it down and have somebody sign it.
Yeah, absolutely. But so many managers don't want to have that uncomfortable
I know.
discussion with employees. It's not until they've enabled the person so much and they've gotten so bad that they have to get them out of there. But there's no kind of paper trail
Yeah.
to allow you to do that. And, they expect us to just, work some magic and get the person out. And it's like, well, you can always do that, but here are the risks. When you
So that's
get rid
the
of somebody.
risk. So the risk in a termination, people will call me all the time. This person's terrible. I want to let them go. I'm like, okay. But, you can, and everyone throws around at will, right? We're in an
Yeah,
at will
all the time.
You
state.
stole my next
Right.
question.
Well, I'm so sorry, but it's not the Wild West. And if you act that way, your employees feel that. Oh, they just let him go and they never warned him, and they'll hear those kinds of things. So you have to kind of start with that backtrack and everything. It's not at will. You have to have that whole first step.
And another good point you just brought up, the giving them an opportunity. In litigation, and I know, Jake, you see this all the time too, one of the worst things for your case is if your client fired somebody without giving them any notice or an opportunity to correct their behavior or their performance. It's damning to the defense of a case, and when my clients call and say, well, they want to get rid of somebody immediately, there's nothing else in their file. My advice is usually, let's figure out, this person might end up getting terminated 3 months from now or 6 months from now, but let's, create that sort of paper trail, start documenting performance or violations or poor attitude situations, and then work it up through your progressive discipline policy until you're at that step of termination, as opposed to just ignoring the prior 4 steps and just cutting them loose right away.
Yeah.
And the only situations where that's ever a good idea is when it's some egregious act like stealing or fighting, something where you really have no choice but to get rid of the employee. But otherwise, it's really important to give that employee an opportunity to correct whatever they're doing wrong.
And so I do want to dive into employment at will just a little bit,
Oh.
because we do have the right. Like I can, pew, 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 just fire people at will. But they have the right to feel a certain way, right? And
There's
that can
risk.
be 100%. They can feel discriminated against. They can feel that there was harassment. They can feel it was retaliatory. So there are big risks that go with just firing at will, correct?
Right.
Yeah.
Absolutely. You guys know that one better than me.
Yeah, everybody thinks, like you said, it's a magic bullet. It's at will. I can do what I want, even if I'm unfair, as long as it's not unlawful. So the general rule is, sure, at will. The law is famous for having general rules and then exceptions. The exception is I can get rid of anybody at any time, not because they're black, not because they're Muslim, not because they're pregnant, not because they're disabled. Hold on, I need more hands. Not because, right? So, I mean, at the end of the day, yeah, there's this great general rule until you realize there are legal restrictions on your ability to exercise your rights, quote unquote, under the at-will doctrine. The other exceptions, and Dave could speak to this more than me, is, you know, if you have a labor union, you have a collective bargaining agreement, you're not at will anymore. You can't just fire anybody at any time. Or if you have an employment agreement with somebody that says something different, right? I'm going to employ you for a period of X amount of time. Well, then your rights are restricted depending what the agreement says, right? Typically, that's for executives and higher level employees, but not always. So there are exceptions, and sometimes the exceptions can feel like they swallow the rule.
Mm-hmm. Those exceptions apply to EPL coverage a lot too. The EPL will generally exclude, you know, collective bargaining situations. It'll generally exclude contracts, written contracts with an employee. So those are things to pay attention to. You listed on your hands as many as you could. I did some research before time.
Too.
So the top 6 equal employment opportunity commission charges. You know, you listed a good number there: age, national origin, sex, race, disability, retaliation. What do you think the number one reason, the number one charge that the EEOC sees is?
You have a guess?
I would guess disability.
I'm pretty confident it's retaliation.
Could you see it? Were you looking?
No.
Oh, you cheated.
Here's why. No. Here's why. It's because you're always going to get your discrimination cases, but almost any more. This wasn't always the case. It's you discriminate against me on the basis of whatever, race, age, sex, disability, all these things. And when I complained about it, or when I told you it was a problem, or when I requested an accommodation, then you fired me. And that's the reason. It was a short time period. So then now you retaliated against me. So every one of those discrimination charges anymore has a retaliation sort of component with it. So, and I think there's a couple extra just straight retaliation charges, right, claims? So
100%, yeah. More than half the claims have a retaliation charge in them.
But some of them have a discrimination and a retaliation
Correct.
with them.
yeah.
Yes,
So-
my percentages add up to more than 100.
Yes. Yeah.
Okay, let's do Q&A if anyone has any Q&A. Otherwise, I can keep asking them questions all day.
So I do have a question. You made a comment, and this is something that we're kind of dealing with literally as we speak, right online. We say that if we write it down, we don't write it down, it didn't happen. But because I do write it down, it doesn't necessarily mean that that's true. Because we're dealing with where we've documented, we've requested signatures, refusal of signatures, we've documented refusal of signatures. But because now these letters are written to us, because of what they write in that letter, they say, well, I put it in an email to you. But if this make it true, I can sign all my emails to the Queen of England, and I'm not.
Before they take this, and it's really them, are you having conversations with witnesses? Is there more than one manager
Absolutely.
present?
Never, at this point, we never met with this individual.
And backing
So
it up
AJ,
with,
just-
yeah.
Heads up, this phone call's coming probably.
And you're backing it with policies and providing evidence. Okay.
Education, training, everything. We've
We have
never,
emails with supporting during his
That might be the
position.
category where you're doing everything right. But for more.
Yeah, I mean, that's the most you can do is document. You know, the pushback I often get from managers and in-house people like, Jake, you're telling me to document everything. If I documented everything that happened that I thought was a problem, could possibly result in one, I would have no time to do my job, right? And my response to them is just keep at it. And it doesn't have to be Shakespearean, right? You don't have to type it all out. It can be handwritten. It can be on a napkin, frankly. Not ideal, but do it, right? Much better than nothing. People refusing, I've never really understood that. My only sort of suggestion associated with that is on the signature line, say, you know, this just acknowledges that I've been spoken to about this, not that I agree to it, right? Because some people don't want to sign because they're fearful if they sign it, they're effectively agreeing that everything that is in the document is accurate, it's true. And look, you can leave for another day the fight over what's true in that document or not. Do your best to get it down. And you know, sometimes you investigate things and you don't, even at the end of your exhaustive, you know, investigation, you've done everything you can think to do, and you're still not even sure what really happened, right? Like, I can't tell objectively. I can't corroborate whether it's yes or no, right? But at least have your documentation and save it and put it in your back pocket. It can be really useful to you, i.e. us, when that employee takes it a step too far and files a later claim. We can still use it. It's still helpful. I wouldn't get too hung up on whether they're signing it or not. Document that whole thing like you're doing. That's the most you can do. If they don't want to play ball, they won't play ball, right? And they probably won't be employed very much longer.
And plus, remember, if the company does get sued after you do the investigation, it's not the burden of the employer to show that in the end you were right. You just have to show that you didn't discriminate against the employee, that you treated them fairly, conducted a fair investigatory process, and arrived at a certain conclusion. You're not always going to be right, but that doesn't result in legal liability just because you were wrong.
We say that.
Yeah,
we
go
say
One of the things that we try to do is when we do have those verbal conversations with people, we'll follow up with an email just to put in a working sites we spoke today about blank, and send it out to them. Just so it also gives them that opportunity to answer right back and say, can we have another conversation about a certain piece of it? But it's also an acknowledgement. Is that like good?
I always say,
Mhm.
please confirm that this is your understanding. Try to get them to respond to it too. You can mark it for read receipt, but you want to understand you're on the same page. If you've asked that employee to confirm that that is what they understood and they took away from it as well, great. If they have a question, to come back to you. Because if you get them to respond to it, they're acknowledging that they had the conversation.
And it even helps if you just start those emails, those letters with, as we discussed today, comma, and then say whatever happened, period. If they don't respond, there's not another document from them that you can imagine. Once it gets to us, that looks pretty good. To anybody listening to the case later on, oh, you confirmed what exactly happened in a document, and the employee didn't think it was important enough to respond, correcting your understanding of what happened. That's pretty good evidence in most cases.
Yeah, not getting into the rules of evidence, but it's a contemporaneous writing that you prepared, which will lend itself to be a greater chance of it being admissible if there is litigation down the road. The fact that right after your meeting you sent this out because everything was fresh in your mind, so it increases the chances that what you put in there is actually true and accurate. So it's definitely a good idea.
I mean, like today's age with AI and surveillance and everything like that, can you record this and then have it transcripted? Shaking your head.
Go ahead, Jake. Dave?
Well, I mean, there is something called the Wiretap Act in Pennsylvania.
No, with everyone knowing.
I mean, if there's like a sign posted that this is being
You say, hey,
recorded,
we're
If everyone's
having a conversation.
consenting.
We're going to interview you about this complaint.
as long as they consent to it,
They have to consent to it.
it's knowledge and consent in order to be recorded.
Sure.
Let me
Say that we consent, and you sign off saying I consent on this. Wouldn't you want to do that?
Yeah, but typically you're not going to get that.
Yeah, they usually won't
You
agree to
wouldn't
that.
get a consent.
If you're sitting an employee down and are we talking about like I have a complaint and you're sitting me down to talk to me and you want me to
All
consent
parties
to it?
included.
They won't sign
Yeah,
the documents.
Then they'll
over
say
there.
they want their lawyer there.
No,
Yeah,
they
so-
don't want that.
Let me give you a good reason not to do that. Almost in any case, you're breeding mistrust, period, end of story. Your other employees realize that you're taking the opportunity to record them at any given time. I don't know what you're going to get back. I don't know who's going to stay employed. I mean, people recording me, I'm leaving. I don't care for what reason. And frankly, you don't really need it if you're doing the documentation. This will confirm, as we discussed. It's my understanding based on your, what you said today, that blah, blah, blah. That's going to be plenty. I think there is this issue of what state are you in. There's a wiretap law. Jersey, by the way, is different than Pennsylvania. Pennsylvania is what they call a two-party consent state or an all-party consent state. Jersey's a one-party, so you'll need one. Eliminate all that complexity and nuance and confusion and just get it done. If you need a witness, that's what I like. So you're having some of these meetings, right? And ordinarily you'd think, well, I can have this one-on-one. If it's important enough, if it's a termination meeting, for example, or something resulting in a PIP, if you can have two people in the room on your side, that's far better than recording them, believe it or not. Yes, your recording might have more, verbatim what was said. But I think for evidentiary purposes, for proof purposes, if you ever need it, having that other body in the room taking some notes, you're in as good shape as if you recorded them in most instances without breeding this sort of underlying notion that we don't trust you, so we're recording you, right? Which filters through the employee population generally. And I think that's sort of a bad message to send. And
I just think a lot of businesses already have cameras and everything like that, so you're getting recorded anyway.
well, ironically, audio is different than visual. Yeah. So
I have a question. So you've done everything right. They're filing suit against you anyway. How often do they see some sort of payout? And I think I know the answer to this, but how often are they getting some sort of financial compensation?
More frequently when they go through E EPLI. No, the reality is a lot of the time, I would say, because not only insurance companies, but employers, if they're not aware at the beginning, they're aware after speaking to Jake or I or whoever their lawyer is, what the costs to defend a lawsuit are.
Mm-hmm.
A lot of these cases that we're talking about, discrimination, harassment, retaliation, they involve fee shifting statutes. So if the plaintiff is eventually successful on any of their claims, they can get their attorney's fees paid by the losing party, the company, in addition to the company paying their own attorney's fees. That always serves as a huge deterrent for a company to go through and battle it to the very end. On top of that, you have all the other damages in these statutes: back pay, front pay, damages for emotional harm, which are called compensatory damages. There's statutory damages. When you do these, the employers or the insurance companies will always ask at some point in litigation, what's the worst case scenario? And you hate to get asked that question because the potential damages in these cases are significant. 6 figures, 7 figures, but you always have to let them know that's if all the stars align. And very rarely does that happen. Chances are it's going to be something far less than that if they lose. But they still just think of the worst case scenario, and that drives them to try to get a settlement eventually. I mean, when the case is initially filed, emotions are high, and they're like, I'm fighting this. There's no way we're going to settle it. After a year of litigation, the tune usually changes a little bit. And they're like, another bill coming in. We're a year into this. My employees are stressed out. We're focusing on this lawsuit as opposed to the work we're supposed to be doing. There's so many distractions involved. And at some point, it kind of wears people down, and then they decide they want to settle the case.
But I do think it depends on what's at stake. Unfortunately, I've worked with a number of companies that have been sued. And you're right. In the beginning, everyone wants to fight it. They have the documentation. They weren't at fault. They want to prove it. But I mean, I've worked with employers that stuck it out, and they really did clear their name because there was no case on the other side. And sometimes you need to do that, but it depends. Is it going to ruin the business? What else is it going to impact? So these scenarios aren't the same. Every single one is different.
Yeah. And I ask that because you do get people who want to fight and get really mad that there was any sort of payout. But there is, the burden on management being tied into this for an extended period of time. So thank you. I see Andrea there. Do we have one more question? I'll let one more question happen.
We said,
Back to the evidence.
wait a minute. This is Tim Charlesworth. He's a shareholder attorney at the traffic authority. Just so you know.
Not the employment group that I know a lot about. I never called these folks. So the manager is out there meeting with troublesome employee, problematic employee. They've taken their notes, either get signed or not signed. Fine. Now they're ready to send their email out. Dave said it should be contemporaneous. It should be happening soon after that meeting, so it's fresh in your mind. Does it also make sense when the email is sent, have somebody like you look at it and say, you can tweak that and make it a little bit better?
Absolutely. I've had many cases where the email or letter that went out to the client, to the employee, had some statement in there when you look at it after the fact and you're like, oh, man.
Or you leave something out.
Or they leave it out. Either it's misstated, left out, and sometimes it's something that can really come back and bite you in a lawsuit.
And
So,
cheaper
definitely.
at that stage than after the mistake.
Yeah, good point.
All right. Then thank you to the panel. This was great. I hope you all got something out of it. There will be, a meet and greet afterwards, so please stick around. What's that?
Just for you, though. Thank you, everyone, for coming out, and thank you to the panel.
Waiters are serving us out there.
Perfect. Thank you.